Good morning, everybody, and welcome to Development Committee 18th of June 2026. My name is Councillor Roy MacDonald and I'll be chairing the Development Committee for this meeting. Before me sit the committee members who will be making the decisions and the debates today, and at either side of me are the officers that are here to advise. Could you introduce yourselves, please?
Good morning, my name is Jeff Lyon. I'm the Development Manager.
I'm Darrell Watson, Development Management Team Leader, standing in for the case officer for the Thorpe-Fakenham application.
Lauren Gregory, Democratic Services.
David Gleeson, Assistant Director for Planning.
To the Council.
Alice Walker, Senior Planning Officer.
Nicola Ray, Training Planning Officer.
Thank you. If necessary, we'll have a break about 11 o'clock. Can I please remind members of the public not to communicate with members of the committee during the meeting or at the break time? And when members come up to speak at the front there, if you could please go back to your seat after you've spoke, that would be good. Thank you. Please can I ask all mobile phones and laptops are switched to silent. We're not expecting a fire alarm, so if the alarm sounds, please follow officers through the marked exits and head out to the designated area at the front. And the toilets, if anybody needs, are out in the foyer. Item 2 is receive apologies for absence.
Thank you, Chairman. Apologies for absence have been received from Councillor Paul Heinrich, Councillor Kim Toy and Councillor Conor Rouse. And if I may, with the next item, we have no substitutes present.
And no items of urgent business?
None received.
The order of business is as is in the agenda. Do we have any declarations of interest, please?
Yeah, Mr. Chairman, I have to declare an interest on item 8 as my property is affected by the planning application.
Thank you, Councillor Tillett. Anybody else? No. We don't have any minutes to go through, so can we go to the first one, which is Fakenham PF 242184, please?
Thank you, Chair. This is the one starting on page 7 of the agenda. This application came to your meeting just under a year ago on the 25th of June 2025. So I'll go through the presentation that you've seen before, just as a reminder, and in case anybody here today wasn't at that meeting. So if we can start, please, Lauren. This first slide shows a general location showing the site within the area designated as countryside under policy SS1 of the local plan, and it shows it in relation to the town centre, Fakenham's designated town centre. Next slide, please. This shows the site location plan. Thorpeland Road runs off the north arm of the roundabout as you enter into Fakenham from the east, where you turn down to Morrison's. This is just showing it overlaid on an aerial photo. The site is outlined in red. This is the existing site plan. It's just a field at the moment, with an access off Thorpeland Road, as you can see on the bottom on the left-hand side. This shows the proposed site plan. The farm shop would be on the southern side of the site, and then there's a bar, kitchen, staff parking, the area of the polytunnels over on the east, on the southern side, and there's the area of car parking, and it's utilising the existing access. This is just a wider site plan. The green is the land that would remain in agricultural use, and the blue is the land which was changed to use Class E as part of the development. These are the proposed elevations. The top left is the east elevation. Then next to that, we've got the proposed west elevation. The middle shows the southern elevation. Then on the bottom, we've got the northern elevation. These are the proposed plans for the restaurant and shop floor plans. So the farm shop is the piece on the right hand side as the slide if you look at it, and you've got the dining area is a larger area in the middle with the kitchen above that. And this shows the proposed WC and bar floor plan. Next, please. This just shows a proposed roof plan, helping to show out the layout of the proposed buildings. And this is a visualisation of the proposed development. This would be what you'd see of the site as you're coming in from the access from the car park. This is a site as existing, looking north. Now looking east. Looking southeast. Now looking south. Look, this one's looking west. And this one's looking northwest. That area of hard standing is near the existing access, I believe. And then look, this is looking south towards the access point to Thorpeland Road from within the site. This is the site access to Thorpeland Road, which is existing. And this is the Thorpeland Road access looking south and then looking north from the access itself. These are the main issues, but I'll just start my sort of presentation now. At your meeting last year, you resolved to give the Assistant Director of Planning authority to approve the application subject to conditions and the Section 106 agreement to include an ongoing link between the ownership of the farm and the business on the development site. The applicant has declined to enter into the Section 106 agreement, so the application is returned to committee in the absence of one, and the application must now be considered against the North Norfolk local plan adopted in December last year, which has replaced the core strategy against which the proposal was considered previously. The decision must now be made in accordance with the local plan unless material considerations indicate otherwise. It is also important to note that there's not a fallback position in this case because the planning permission wasn't granted. So the new policy considerations are set out in the addendum report. With regards to the principle of development, the site lies in the countryside policy area where development is restricted. The policy SS2 specifies types of development that can be acceptable where they comply with all other relevant policies in the local plan. As set out in the report, now there's not a specific farm diversification policy in the local plan, unlike there was in the core strategy. Local plan policy E4, which relates to retail and town centre development, is therefore the most relevant policy in the local plan against which to assess this proposed development. The proposal fails to comply with E4 because it's not of a proportionate small scale as the policy requires. The cafe and associated kitchen and bar dominate over the farm shop, which accounts for only 20% of the proposed floor space, such that the cafe, etc., are not ancillary to it. A relevant recent appeal decision relating to a similar type of proposal at Sharrington is referred to in the report. The appeal considered the local plan policies which are relevant in this case. Of particular relevance is the inspector's reference to the unilateral undertaking given by the appellants, providing an effective link between the proposed development and the wider farming enterprise. The completion of a Section 106 unilateral undertaking would in the case of the current application ensure that the proposed development will be linked to the farming enterprise. Officers considered this is essential should committee resolve to approve the application. Without it, there'd be no mechanism to tie the land to the farming enterprise, and it's not a matter that could be dealt with through a planning condition. A condition could limit the produce sold, as explained in the report, but this can only be given limited weight. Turning to other policies which were not, there weren't similar policies in the core strategy, is the The first one is the policy CC3, which relates to sustainable construction. As the floor space of the development exceeds 250 square metres, the policy requires that the BREEAM very good standard is achieved. The policy requires a compliance statement, but in this case, it's not being provided. The applicant argues that this compliance would make the scheme unviable and proposes alternative sustainability measures, but officers only give them limited weight. With regards to policy CC4, water efficiency, the applicant has confirmed they would agree to a condition to secure compliance. In regard to transport and accessibility, the site is in an unsustainable location. It is poor access by walking, cycling and public transport. It is contrary to policy CC9 of the local plan and the NPPF's transport sustainability objectives. Parking provision is, however, acceptable, including some EV charging. Though the EV charging provision is below the policy requirement, it is considered acceptable in this case, having regard to the specific circumstances. So the conclusion and planning balance is that the proposal conflicts with the key local plan policies, E4 in particular, because the proposed development would clearly go beyond the scale of the retail development envisaged by local plan policy E4, as the policy is clear in requiring development in the countryside to perform a wholly ancillary role to an existing or planned use and is of appropriate and proportionate small scale. The scale of the development proposed is considered significant and the need for the developments has not been adequately justified. With regard to CC9, it's in an unsustainable location and realistically only accessible by car, and it doesn't comply with CC3 for the reasons I explained a few moments ago. The limited economic benefits and the fact that proposal is acceptable in all other respects does not outweigh the harm from the policy conflicts referred to. The recommendation is therefore refusal for the reasons set out on page 12 of the agenda. Thank you, Chair.
Thank you very much. And we've got from Mrs. Glenn from the Town and Parish Council, Fakenham Town Council. Can you come up and talk, please, at the front? You've got 3 minutes.
Good morning. Thank you for taking the time to listen to me this morning. Whilst I accept that last year the committee, after some deliberation, agreed to hand over the planning permission to officers, I would point out that the address on the planning application is wrong. It's not Salmons Lane, it's Salmons Land, Thorpeland Road. Thorpeland Road is bisected by the bypass when it was built. The existing part of Thorpeland Road, which a lot of people walk down, is completely sequestered behind Morrison's, and people do walk down there and cross over to go to the Fat Cow now. So to say that it's unsustainable, it's 200 metres to walk from the junction to the Fat Cow as it exists now. You made your decision last year, and it was to the evident delight of the applicants and also to Fakenham Town Council. The Section 106 condition that was imposed that ties ownership of the farm shop to the land, we think is, whilst it's part of your policy, we think it's an unwise thing to do. We think that nobody would start a business in this economic climate if they weren't able to realise something from it in the future, should they need to. And at a time when this country needs all the new businesses it can get to improve economic growth, the impositions seem incomprehensible. The elected representatives agreed last year, but officers' demands make it virtually impossible to proceed with the development, which is why we're all here again today. Fakenham Town Council overwhelmingly supported the application last year and does so again this year. Having a farm shop that's easily accessible, as I said, people can often be seen walking and cycling to the existing Fat Cow. We urge you to overrule the constraints within your policy and to agree to this application to go ahead, because in comparison to the garish new addition of the EV charging points and the Burger King, we think it will be a welcome addition to the town. Thank you.
Thank you very much. No objecting speakers. We got a supporting speaker, Mr. Spencer Ashworth. Can you come up and talk, please? You've got 3 minutes.
Good morning, members. A year ago, you gave your overwhelming support to our proposal for a permanent restaurant and farm shop, building on our successful pop-up burger enterprise. We remain extremely grateful for that and are eager to deliver the project that you approved. Unfortunately, we've not been able to progress the project because of the Section 106 obligation requiring the site to remain tied to the ownership of our wider farm. We feel we cannot accept this restriction, and this is the reason we're here today. We understand the approval was based on the project being a farm diversification, but this goes much further than simply ensuring that the development serves the farm business. In practical terms, it creates a major obstacle to investment. The project has been independently costed at over £1.5 million. No responsible business, let alone a farm, can invest that level of capital into an asset that can never be separated from the wider holding if circumstances change in the future. We have absolutely no intention of selling the site, but farming is an increasingly challenging and unpredictable industry. We have to plan not only for today's circumstances, but for events that may arise in 10, 20 or 30 years from now. As we have seen, government policy and global events can change things overnight. The proposed obligation would remove all financial flexibility. It would significantly affect the value of the asset and make it difficult to raise finance against it to fund its construction. In short, the obligation makes the scheme uninvestable. This Section 106 is not required by planning policy, to our understanding. We respectfully suggest that the obligation is disproportionate to the concerns it seeks to address and places an unacceptable burden on a small family farming business. On the issue of BREEAM, we would ask members to recognise that this policy was not in force when our application was submitted, nor when the scheme was considered by you last year. The building was designed as an open-sided, unheated agricultural-style barn. As such, it cannot easily fulfil all the constraints of BREEAM, but is nevertheless a highly sustainable building. We are advised that BREEAM compliance is likely to add around £15,000 in consultant fees before any construction costs are considered. This places yet further pressure on the viability of the scheme. We therefore ask members to weigh the limited benefits of applying this requirement against the considerable benefits that this project will deliver. But ultimately, the reason we are here today is to ask you to reconsider the unnecessary Section 106. We do not take the decision to come before you lightly, but this is make or break for our project. It saddens me to say that farming is in a desperate situation. We must diversify if we are to survive. Over the last 5 years, we have built a successful summer business that people love. And last year, you backed us to build on the success and create a permanent home for it to grow. We respectfully ask that you once again support this proposal so that 2 years on, we can finally move forward to making it a reality. Thank you.
Thank you very much.
Something. This Section 106 agreement started off negotiations this time last year. And the solicitors for the applicant said we have a problem with such a large estate that we have a number of sell-offs interests already, including a traveller's site, some barns which were converted to residential buildings, the agricultural farms, the farmhouses, and the council officers were very commercial about it, considered the position and came back with saying, we understand all of that, we understand. And so to pay lip service to what the committee resolved, they agreed not to bind anything at all, except 2 fields. So we less than 5% maybe of the land holding. So whilst we had enormous plans like this, which showed the titles and the very, very large estates, all that the Section 106 would bind is 2 fields, 2 agricultural fields, because the council were very aware of the commercial realities. That document was agreed in November 2025, but because of the we had a fair amount of delays. I won't go into it. The solicitors were very busy at the time, acting for on a lot of matters, and I've just reviewed the file, and we chased and chased and chased on it quite a lot. But actually, the biggest delay was about the mortgage company and sorting that out. And we do understand that. So I think just going forward, members need to understand that the council were not commercially unaware. all they agreed to say at the end of the day is they added as much flexibility as they could, and only 2 agricultural fields, not even the farmhouse or any properties or anything, was linked to the farm shop.
Sorry, sir, we got councillor Cushion, the ward member to speak yet. Thank you. If you could go, councillor Cushion.
Just putting my stopwatch on, Mr. Chair, thank you. Thank you very much, and thank you for members. I have to say it is disappointing that we had to come back here today. I will remind members of what happened 12 months ago. When this was presented, officers stated that there were a number of planning conditions that this application didn't quite meet. However, members in their judgments decided to overrule that, and they overruled that by a significant margin. If memory serves, that was about 10 votes, 11 votes for, with 1 abstention. So there was a clear intent from the Development Committee that they did support this application. And if you recall, and I suspect it's the same with most of the applications you approve, very little debate was given over to the conditions. They were simply delegated to the officers, and it was assumed that that would be fine. And indeed, the last conversation I had with Officer Russell Williams before he left the authority was that we understand the intent of the Development Committee to get this, make this happen. So that was where we left it. I'll let, if he may, Mr. Spencer Ashford ask to the points that the solicitor has just raised, but I will put one thing, say this. Having lived in the area, I know this. This farming family is not one of the really big boys locally. This is not a West Barsham estate. It is not a Walsingham estate. It is not a Holcombe estate. They do not have tens of thousands of acres sitting behind them to do that. And if they are doing other things, then they are doing what all farmers have to do at the moment, which is diversify their businesses. And farming business has never been under greater pressure. And indeed, the recent war in Iran has just made life even more difficult. For example, the price of fertilizer is going up by 40%, and you look at weather we've had this year, very little rain in May, so the crops probably won't be great. It is a tremendous business that they've set up. It is very popular locally. Looks huge support online for this. Now, I don't like to criticise officers, but I mean, there are 2 sides to every story. And I really would hope, given that the circumstances that this council want to do, bend over backwards to help local businesses and plot their way through the planning regulations. And it really doesn't appear that this has happened this time. Now, it's not to speak for the whole council. The economic development team is fully supportive of this. Stuart Dancing last year wrote some very strong words, hoping that this would be approved. I will pick up on some of the things. One of the points made, Mr. Spencer Ashford has answered some of the points, but I'll ask one of the key objections in this on, I think, page 12. The first one is about the accessibility and pedestrians be able to get to it. It should be what source for Greece is source for the ground on this. If you go 10 minutes up the road to Leathering Set, you come to Jarrell's restaurant. There's absolutely no way you could reach that on foot, and you actually take your life in your hands trying to get there on bicycle. And I suspect if this rule was retrospectively applied, half the restaurants and pubs in North would have to close. We live in a very rural area. We rely on the tourist economy. We expect people to come here. We have to use cars whether we like it or not. The other thing I want to just mention that's happened in the last 12 months is 2 other planning applications that have been approved in the town. One is for a McDonald's restaurant. That's less than 5 minutes drive from this site. And another one is for that was when it opened last December. And another one was for Burger King, which opened at the Morrison's petrol station, which is literally 2 minutes drive from this site. Well, you can't get to either. Well, actually, certainly the Burger King is a takeaway, so you can't get there for any other reason by a car. I'd also say, what does the optics look like for this council? We approve planning permissions for 2 large global purveyors of junk food, yet we crack down on the little guy selling quality food with no preservatives or no additives in it. I do ask you to consider that very carefully. End of the day, I don't know, but I'm assuming the applicants have probably spent tens of thousands of pounds to get to this point, to try and establish a small business, and their fate obviously lies in your hands. And that is the great benefit of having a development committee. You can stand back and look for the greater good, and I'd say good can only come from this. Good for the survival and growth of the applicant's business, good for our local economy and businesses that supply this enterprise, good for people who will use this, good for people that they will employ. So I really do hope you look at this application once again and do as you did last year, please, and support their application, reject the opposite recommendation. Thank you.
Thank you, councillor. I'm of a mind to let Mr. Spencer Ashworth was to respond, but I don't want to turn this into a three-way conversation where it continues. So if I let Mr. Spencer Ashworth respond, can we not have it that we're continually asking him to come up and keep on responding to things? Would that make sense to everybody? So well, do you think I should ask him to respond now, or do you think, yeah, please come up and respond. Thank you. I think it's just a response. Yeah, that's fine. Go for it.
Thank you for giving me the chance to do that. And if I could just respond to the points you're making, I'd respectfully say that it's not two fields, it's two blocks. There's actually 4 fields. I can name them to you: barn field, bean field, footpath, and the top orchard. And I appreciate that there was the council legal team did try and be flexible about the amount of fields involved. But what we understood was absolutely key to it is that it was around the core farm. They're not 2 fields on the edge of the farm that we could, I mean, not that we want to get rid of any of them that we could just sell willy-nilly. They are 4 fields around the core of our farm that if we sold those, that is it for us as farmers. My father is buried about 2 meters the other side of the hedge of those fields. That would be it. So it is extremely personal, and it's not something that we can, it would tie it to the future of our farming business, full stop.
Thank you. Thank you.
I can just say I do understand, but Fraser Dorbarns wrote in September, and that was the proposal they put forward, and they actually said for tax planning reasons and things like that, the fields, whatever, and she actually said, can we please not have all the rest of the farm diversification things put in there? So actually that was a proposal made by your solicitors in a very long letter, which we agreed to, and we said we're very happy to exclude everything you're requesting, including the traveller site, the barns converted to residential use, possible development land north of the A148, and some farm buildings, and in fact no buildings whatsoever on the entire estate are bound. So I'm not quite sure why in September last year the plan proposed of what appears to be 2 fields was put forward by your solicitors as the proposal. I do understand what you're saying, but I do think honesty should prevail here. That's all I'm saying.
Well, I think perhaps there was some confusion, but we understood the principle was that it had to be to the court in order to bind the farm. But I apologise if there's miscommunication, but that was our understanding. Thank you very much.
Sorry, thank you. I can't go to a conversation. Sorry, Ed, speak, Jeff.
Yeah, I mean, this is clearly not an easy application in terms of weighing up the policy issues. And I think it's clear this is a departure from your current development plan. Clearly the applicant isn't willing to sign a Section 106 agreement. So negotiations about what was in, what was out, it's necessarily relevant to this consideration, because clearly the applicant said they are not prepared to sign a legal agreement. So we're in a situation where you as a committee have to make a planning judgment on the proposal before you, knowing that a Section 106 obligation tying land to this development will not materialise. So and local members made reference to a number of schemes in Fakenham. So both of those other restaurants were in the town centre, in the development area of Fakenham, were in accordance with policy. So that's a materially different position to the site we're at here. There was reference to a farm shop on the edge of Holt. Again, that was a conversion of existing buildings, whereas here we are talking about entirely new build construction in the countryside. So the policy difference is significant in terms of how you assess the application. Now, if we were talking about conversion of the buildings to provide this facility, then I think we would have recommended approval if we're being honest, but we're not in that position. And the importance of being able to tie the fields to this development is so that if we don't differentiate this from anything else, what's to stop another developer coming in and saying, well, I've got a countryside location, you granted permission here, I want something similar. We open the floodgates, and it's understanding how do we differentiate this from anything else? What are the material considerations that justify departing from your policy? Those are the things that you need to have in your mind when assessing this application. We've given you our view. We have concerns about the accessibility by modes other than the car. There's been talk about, yes, you can walk across the site from Fakenham, but it's a dangerous crossing going over the A148, and we wouldn't want to be encouraging more people to do that and the accidents that might result from that. So we've taken a balanced view. It's up to you as a committee how you weigh those issues, but we've suggested you refuse the application. Thank you.
Thank you, Jeff. Councillor Hankin first, and then Councillor Patterson.
Thank you, Mr. Chairman. When this application first came to the committee last year, it was very clear from the proposal from the applicant that this was a farm diversification project in order to make the farm itself sustainable, which the figures that were presented made it clear that that was very marginal. So that was the principle that certainly I voted for the application. Now, we've heard a lot this morning about Section 106, whether it's 2 fields or 4 fields. Can I understand in plain language what the objection is from 106 to this particular application? Is it the fact that the applicant is not prepared to link the whole farm to this project? Is it the fact that he's being constrained to 2 fields or 4 fields? That's not clear. Can we understand that, Mr. Chairman?
Thank you. I think you already answered it, but go.
Yeah, it's simply that we took on board all the applicants' concerns, met very early on in September, and said we do agree that in your situation, with all your diversifications already and all your leases and all your proposed potential development proposals, all the council, we take on board everything you say, and therefore we agree with your solicitor's proposal that all we agree to being linked to the farm shop, I've got the plan here supplied to us, are what appears to be, and I do apologise, it's obviously 4 fields, but you'll see 2 areas of red, which we understood to be 2 agricultural fields only. So the linkage would be 2 agricultural fields which don't have leases on them or aren't potential development potential or wasn't the traveller's site which is leased out or anything, just 2 fields. And that was intended to pay lip service to what the committee proposed. And now the applicant, having agreed this wording and the plans in September, November of last year, do not wish to go forward with any linkage. That's just the facts on it.
Councillor Hankin.
So eventually, we're talking about a legal agreement. Yes? Okay, thank you.
Councillor Patterson.
Thank you, Chair. Maybe not a surprise to us that 2 solicitors couldn't agree, which is a shame. That's kind of goes to the territory. I guess for family farming businesses or family businesses full stop are always not straightforward in how ownership works and that side of life. So perhaps there's something we're not seeing there, and that's what we're not understanding. And I understand the rationale of the policy we've got in place to then to why we want this Section 106, but if it's stopping this project being delivered practically on the ground, that seems a real shame. Yeah, I think the material consideration for me is that they are a farming family, and I feel they have farmed in the area for a while. I don't know how long. So I feel that's the difference between here against if we get another application put in front of us for somebody who's just bought a field and tries to put something in it. So I probably wouldn't go with the officer's recommendation. Thank you.
I would just say on the 106, sorry about all this, that it does allow the farm to, the proposal, the development to be leased out. It was only the linkage of the freehold. So there could be a lease over it.
Thank you.
Councillor Vickers.
I think committee members should bear in mind that there's already a successful business on site, albeit in a truck. And so all the traffic objections of people coming in and out, I think need to be set aside because they've already got that traffic presence. And I think Mrs. Glynn is right. There are ways, shortcuts to the farm. And Mr. Lyons points out that McDonald's and Burger King are in the town centre. But if you think that they're both drive-through setups, Burger King is actually in a petrol station. So if you think that people walk to them, that's for the birds, they don't. So I don't see why this application should be discriminated against. I'd like clarification about the two fields. Are those the fields on which the farm shop and cafe will be built?
No, they're just two agricultural fields. And what committee resolved that there should be a linkage? So we just tried to work through that. There was no disagreement between the solicitors. The document was agreed in November, and the problem was that we had to wait for Lloyds Bank and the mortgage company who tried to resolve, took about 8 months to sort things out. So it was just trying to, you resolved that there should be a linkage. So we said, okay, we'll give lip service to what the committee resolved by saying that the family, the farm shop, the ownership of the farm shop on which it stands, the land, will be owned by the same parties who own the two fields. And that was agreed essentially because the council gave so many concessions just to try and work around it. But now the position is the family do not want, or they're instructed there is no linkage. They do not want a linkage to the farm. So there would be a separation between potentially ownership of the land on which the restaurant and the farm shop stands and the rest of the farm estate.
Thank you. Thank you, Chairman. Yes, I mean, I'm not criticising planning officers in any way. We have a top-notch planning department and they are very much bound by the rules. We have more leeway to consider this. What the applicant is saying is that this is not commercially viable. You cannot expect someone to set up a business which actually enhances North Norfolk, enhances selling whole food without preservatives and encouraging tourism, and then expect them to have a business that is not commercially viable. So I'd be very happy to support this application, and I'm sorry planning officers go against your recommendation.
Councillor Holiday, please.
Thank you, Chair. It isn't policy compliant, though I disagree with the assessment against EC4 and CC9. That's the sort of development of an existing business and sustainability, because there is an existing mini business there. And I don't see how driving through a fast food can be any more sustainable than driving 100 yards to somewhere to eat healthy food. I'm struggling with that. I'm a bit uncomfortable with the Section 106 loss, I must say, because I see the point about the floodgates. But I'd like to see a revised viability assessment because there seems to be some questions about that. And to me, what's most germane is, you know, how this will positively influence the bottom line for the farm. And I'm not sure we've got evidence of that. I'm not sure which way I'm going now. I'm quite struggling with this one.
Thank you. Can we go Councillor Brown and then Councillor Patterson, because it's your second, Councillor Brown.
Thank you, Mr. Chairman. Good morning, everybody. To use a football analogy, this is the second half we're playing in now, because the decision we made previously was subject to a 106, so it was a conditional decision, and I think we've read in the papers that no decision notice was actually issued, because it is subject to a Section 106 agreement being in place. I think it would be useful to have a little bit more flesh on the bones of why a planning condition wouldn't work. I think that would benefit everybody in the room and beyond if we could just revisit the reasons for that. As I understand, the fly in the ointment here is more Lloyds Bank. Perhaps shouldn't, other lenders are available. And what I don't think I'm clear about from the applicant is whether every other mortgage funding source has been exhausted, because the mortgage lenders have different criteria, and whether the whole mortgage market is finding this agreement a problem, or whether an alternative funding source may not find that it is such a problem. That's another sort of outstanding question I've got. There isn't an existing business, just to address Councillor Vickers' point, because what operates there at the moment is under the 28-day permitted development rule. So it's not a permanent established business. That's why this planning application is before us, because obviously the applicant is looking for some permanency moving forward. I'm exactly on the same page as Councillor Cushing as regards, you know, national junk food operations. I flew the flag in Sheringham to attempt to lock Domino's out of Sheringham, but it was overturned on appeal. So I get, and that's why we wanted to approve it last year, that this operation is providing much more nutritious alternatives to our, better be careful what I say here. I don't want to get too critical about the two large chain operators that have moved into Fakenham under an entirely different policy, I have to say. And I get that they've, you know, with this, the extension scheme to North Walsham, the town's going to morph out to this site. Sorry, Fakenham. We've got that many extensions to our market towns. Apologies. It will be, you know, it will move out, and I entirely accept Councillor Vickers' point that, you know, people don't tend to walk to these outlets, and that's been demonstrated in comparison to other locations which have been refused recently, most notably Sharrington Strawberries. I would like to find a way around this. I really would. I want this to be policy compliant. But here's the thing. The risk here is that if we ignore the 106 agreement, we are hoisting the flag to farmers to diversify, to eventually have the opportunity to offload their business to somebody that's more like Burger King and McDonald's than what is proposed in this application. That's the rub of this case. And that's what we have to address as a committee. And we've recently done it in Sharrington. We have to be very, very careful. And it pains me to say it because we do want to support business. This administration does like to support business through the planning process, but we have to be careful.
Sorry, can I just say the charge has been released in a letter of the 7th, email of the 7th of May. The discharge of the charge has been completed and was with the Land Registry for registration. So that was the 7th of May. So it's not really about Lloyd's.
That's very important. Thank you. That's a very, very important piece of information in the scheme of things.
Thank you. Jeff?
Just two very brief points picking up what's been said. Firstly, on the sustainability point, I mean, I take the point that drive-through restaurants encourage people to drive through, but the purpose of having a policy that encourages sustainability is that you're giving people the ability or the option to walk or cycle to facilities. When they're away from centres and people can't get by foot or by cycle, they have to go in a car. That's the point of trying to direct development to the more sustainable locations. And just on the point about, obviously I've heard lots of commentary about the operator and how good their offering is. Absent a Section 106 agreement, all you're doing is granting permission for use of land for a restaurant. It's not the operator that you're giving permission for, it's the use of land. So without that restriction, there's a risk that it could be sold to anybody who might want to operate a restaurant or a farm shop in that location. That's the difference, and that's the nub of the issue.
Councillor Patterson?
Well, actually, well, it's not actually, but I can go with what Councillor Brown said. There just feels like there's a little bit of information missing here somewhere around the mortgage side, or something that would perhaps give us a bit of clarity here.
Councillor Netherby?
Sorry, I've got a red light on the wrong one. And I agree with all the comments of my colleagues on the committee here. This is a real tough one. I do support entirely the principle of what they're doing. I think we all like to eat good food. I don't argue with the question about travelling to it. We do it all the time. We live rurally. Equally, I don't want to clash with the officer because they've done their job, and that's right. Can I just ask one quick answer? I haven't heard the answer to this. The applicant doesn't want to do the 106 agreement. We've heard that. We've had the explanation explained that was offered to us and what we've tried to do, and I understand that the officers are bent over backwards to try and accommodate it. Has the applicant made any offer alternatively to compensate for the fact that the 106 is not acceptable in order to try and get these applications through?
Yeah, I don't know. This is the file. It's the paper file. It's quite thick, and I reviewed it a few days ago, and we were saying, you know, we're totally engaged on this. I mean, you can probably hear my frustration on it. Totally engaged with trying to be eminently pragmatic. I mean, I wasn't at committee. I think I had annual leave when this application first came to committee, and so the instructions were to pursue the 106. And the council has really tried to be sensible about it and accommodating. And I don't quite know myself, if it was 4 fields rather than 2, why didn't we have a counter proposal that maybe just 2 fields were bound? If it's a farm diversification, and the family want to continue to run the farm, I don't understand the in-principle objection to binding 2 fields to the farm shop and whatever. And I'd be quite interested to know why there is an objection to it, given that the flexibility in the 106 unilateral undertaking was quite broad. We said that, in fact, it can be owned by the outer family, so cousins and whatever could have a linkage. And also, we were very, very good about saying that whilst the freehold can be bound, you can have leases. You can lease out the property, you know, on ongoing leases. So really, we were paying very strong lip service to what the committee wanted while trying to exercise extreme pragmatism. And I never quite understood why, under the commercial realities and everything, this 106 would not be acceptable, given how, you know, flexible the council was about it.
Councillor Netherby and then Councillor Fitzgerald.
Thank you, Chair. Can I ask a question that I'm sure I should already know the answer to? If the business were to fail and subsequently close, what happens to the 106? Does that simply cease to be?
Yeah, effectively, because there is no linkage, no business. And also, if with a 106 unilateral undertaking, if circumstances change, policy changes, practicalities change, 5 years after the 106 is entered into, an applicant can apply for a discharge of those obligations. Or if perhaps something came up after the 106 is entered into, you know, I think officers look at this and, you know, it's like the agricultural links, the farm worker agricultural links, you know, we're often getting, because circumstances have changed over 30 years, we're often getting applications to discharge 106s, which, or Section 52 agreements, which have the linkage. So if circumstances change, again, there is this flexibility, you know, inbuilt. I don't know why there wasn't resistance last year to the linkage, and I don't quite understand myself why there is a resistance to the linkage. As I say, the council agreed not to link. We did keep asking what percentage of farm area are we linking? Is it not, you know, is it less than 10%? Is it 3% of linkage? You know, and we asked the solicitors about 4 times and we never ever got a response. But you can see the council was trying to be extremely flexible around it. And I think if they come back and said, look, only 2 fields, 2 small fields are linking, we'd probably have said yes. You know, we want to be engaging, you know, we do understand everything that, you know, we were trying to pay lip service to what the committee's resolution was, and what they perceived, you know, could be a nice farm shop.
Councillor Fitzgerald.
Thank you, Mr. Chairman. I heard alarm bells with what Jeff was saying to us, and I think we're getting a little bit sort of buried in the mire and the myths and everything else. But the point being is that if this land is not linked to the farm, sorry, if this business is not linked to the farm in some way, then that will open the floodgates to any landowner anywhere in this district to actually do what they like with a bit of land. And I just urge caution on not opening those floodgates.
Does that mean that you're going to propose the motion?
With regret, because I would support every possible farmer in the whole of this country, I will propose refusal.
Thank you very much. Councillor Vickers.
I will second that, Mr. Chairman, reluctantly.
So may I speak, Chairman? Just before we go to the vote, I just want to point out this is not the depths of the countryside. It's only on the other side of the road from Morrison's. And what I see is a small farm trying to turn an honest penny. Is there any compromise? I hear what people say about it could be sold to a junk food operative. Could that not be addressed by putting covenants on it which restrict the use so that it couldn't be sold to Pizza Hut or other establishments?
The applicant wants to say something. Is he allowed to?
Yeah. If you come up and speak, that would be fine. Thank you. So, Which question are you responding to?
Well, I feel I ought to respond to the points about the bank and the process that we've been through, and also whether any alternatives have been proposed about the linkage. So just to clarify the point about the bank, we had an existing charge for a small overdraft over the land, and that the reason the process has taken so long with Lloyd's is because in order to get the Section 106 signed, we had that charge had to be released. So that's a separate issue from us funding £1.5 million worth of development. That's two completely separate things. They just happen to both involve banks. I understand from a legal perspective, it seemed like we kind of all agreed, but there'd actually been several months of back and forward with the planners before we ever got to the legal point, and we'd resisted very, very strongly the Section 106, and we'd been advised by our planning consultants that it wasn't actually required by policy, and I'd personally be interested to understand where it actually says in the policy that the Section 106 is required. We were told after much back and forth that we had no choice, and that if we wanted this application, then we would have to sign. And so at that point, we entered an agreement, and we were advised by our solicitors that it would have to be the core of the farm. That was, and perhaps there was a miscommunication there, because that's maybe that never came from you, but we were advised that was what was required. And if it hadn't, if it had been maybe a field that was less sensitive, that if everything went to hell and that field had to go with it, then there wouldn't have been such a disaster. So perhaps there was a miscommunication there, and if there is, then I apologize, but there's been multiple lawyers in between. And just to the but during that process, which has taken many months with Lloyd's, we had the proposal costed up, and we just realized that we can't put that land, which we'd understood was the sort of minimum requirement, we just couldn't put that land at risk with this level of investment. So perhaps there was an alternative, and if there was, I'm very regretful that we didn't get to that point. On the point about whether there's whether we've offered some other proposals, I mean, we felt that we'd already kind of agreed that way back when, before we came to this committee the last time, when we agreed that the farm shop would be, and I forget the percentage, I think it's 80%. Sorry, off the top of my head, I can't remember, in terms of produce from Norfolk. So that ensured that specifically the farm shop and actually the restaurant, but the condition applied to the farm shop was entirely, or almost entirely, from Norfolk, and therefore it's not something that Burger King or Wetherspoons are going to be interested in. So to us, that felt like it kind of kept it true to its intentions and kept it local. Thank you very much.
Thank you. Can we move for the officer's recommendation? Go for a vote on that first. Oh, but Councillor Fisher, sorry.
Thank you, Mr. Chairman. Usually by this point, there has been quite a lot of clarity in my mind. I feel as though I'm a bit more confused now than I was when I walked in the room. It seems as though without the Section 106 agreement, it's going to be very difficult for us to allow this to go against the officer's recommendations and allow this to go through. I hear also that the CC9 sustainable transport is not an issue because it's just the other side of Morrison's, but just the other side of Morrison's is the A148 and a roundabout. And while I take my life in my hands sometimes and cross the A148, I don't do it at a roundabout. And that concerns me greatly, that if we should allow this to go through, that there may be an issue there. But at the moment, without this Section 106, however kind we tried to be to forget about CC3, CC9, E4, I fear that Section 106 is ruling the day and the lack of it, and I will have to vote with the officer's recommendations.
Thank you. Councillor Patterson, third and last time.
Thank you, Chair. Just it was just that the section 106 did sound really flexible, sound like you worked really hard. So it did sound like from our side, we weren't obstinate, which is great to hear, like how flexible you were. So just wanted that minuted, I suppose. Yeah, it looks like you really did. Yeah. And interesting that you had allowed a leasehold, so that actually wouldn't have tied the operator to actually running it, the owner to operating it as well. So sort of undermines a little bit what Jeff said about it could be anybody coming on here, because, well, it could anyway with the section 106. So that undermines that a little bit. Are there any other conditions we could impose that would satisfy the committee? And the other question I had is, what were the list of conditions? Because have we actually forgotten those? Because actually, if one of them is that 70% produce has to be from Norfolk, that's going to limit, as the applicant said, who goes in there. So what were can we be reminded of the other conditions that would sort of curtail who would take that site on and how it looks and how it's run?
Yeah, we had a set of conditions ready to attach to a decision notice if the section 106 was signed. One of those was there's at least 70% of the goods by product line to be sold or offered for sale or consumption from the farm shop shall be limited to produce grown, reared or produced within the county of Norfolk. That's probably the most relevant one in this case. And then there was an associated condition which said, upon request by the local planning authority, the occupiers got to provide evidence that they're complying with that condition. And there was a limitation on the floor space of the to be used for a restaurant, no more than 250 square meters to be used as a restaurant, no more than 150 square meters to be used as a farm shop. So the other conditions which we were recommending were just sort of standard things to do, landscaping, lighting, etc., materials.
Okay, so that rules out that a national is going to come in here and run this, because we've got that condition in that place. So we've got a condition that protects the kind of offering that is there by saying 70% of the produce must come from the county.
Councillor Hankin, and then can we go to the vote?
Thank you. Look, I respect the fact that the council and the applicant have put a lot of work into trying to find a solution to this problem. The fact is, they haven't found a solution. That's the fact that there is still a significant disagreement between the applicant and the council on various points of law, etc. I think personally, there's always a way where there's a will, quite frankly. And I think it is worth going back and looking at this and looking to use some lateral thinking to see whether or not this can be gotten around, for want of a better expression. Thank you.
Thank you for your indulgence, Chairman. I certainly would support what Councillor Hankins says. I think if the applicant is willing to talk again, I mean, he said there may have been some misunderstandings, perhaps it could go back and you know, you could think again before we take a vote on this.
Would you be prepared to link any field? Sorry to put you on the spot.
So no, so it's not on the microphone, but so it's not recorded this, but I've been told we need to go vote on the recommendation first before anything's decided. We need to vote on the recommendation by the officer.
You not vote for adjournment, you know, postponement, and so to give the solicitor and the applicant chance to speak.
So we have a proposer and a seconder. Unless that proposer and seconder wish to withdraw their proposer and seconding for a deferment, I'm not certain from listening to members in the room that an adjournment of a certain period of time would necessarily resolve this. but there is a proposal on the floor. So unless that proposal is withdrawn, we would move ahead with the proposal for the officer's recommendation.
I take it, are they going?
I can't see how anything has changed. I think we need to go to the vote. And then
Okay.
if things change,
Yeah.
we can go forward from there.
Agreed.
That's okay with you, Mr.
Yes,
Chairman?
it is. So we go to the vote on refusal, please.
Thank you, Chairman. So just to confirm that a vote for is a vote for refusal. Councillor Beattie.
With great regret for.
Councillor Brown.
Likewise, with a heavy heart for.
Councillor Fisher.
Yes, indeed, for.
Councillor Fitch-Stillett. For. Councillor Hankins. Councillor Holiday. Councillor MacDonald.
Regrettably, for.
Councillor Neverway. Councillor Patterson.
Against.
And Councillor Vickers.
Against.
So that is 7 votes for, 3 against. The officer's recommendation is carried.
Sorry, councillor's recommendation carried. Move on to the next.
Mr. Chairman, it's fairly obviously the committee is very keen for this to go through. Can we please ask that the applicant can move this forward and don't just stop it now? See if they can move this forward and come before us again.
I agree. It would be good. Councillor Neverway.
Yeah, I absolutely support my colleague's statement. I'm sure if there's a willingness to offer land against the S106 and it came back to this committee, I have no doubt at all this committee would approve it.
I have to say the wording is agreed.
Okay.
Chair, if I can add to that and have my remarks accord with Councillor Fisher and Councillor Netherway as the portfolio holder as well, please.
Thank you, Councillor Brown. I think we have a break for coffee and that.
Mr. Chairman, can I just ask one very quick question of it? So if the applicant goes away, in terms of costs to him, he's obviously borne a lot of costs to do this. Is there any way that he can go back and have another negotiation, which is not going to incur additional planning fees?
No legal costs were incurred because we didn't get a cost undertaking.
Going forward, if you have another negotiation, because obviously it's been refused now, so could he still have a negotiation with you that effectively doesn't have to reapply?
You mean submit the application again?
If he has a negotiation with you, will it cost him any more money to come back again? That's what a simple question I'm asking.
The government have taken away the free go option, so there would be a planning fee for a planning application. That's a national requirement, but that wouldn't stop if the assistant director is agreeable to a pre-app negotiation before the new application is submitted.
Thank you. We have a break now. I think we all need a break after that. I do. Thank you. 15-minute break. Thank you. Welcome back, everybody. I hope we've all recovered. We're moving on to the Poppyland PF 250902. If we could have presentation, please.
Thank you, Chair. Yep, this is application reference PF 250902 for land at Forest Park, Northreps Road, Northreps. The proposal is the installation of sections of new footpath along with the upgrade of surfacing of existing areas and to use as permissive footpaths to create a single new connected walkway with rest stop areas and interpretation boards. And the work is largely retrospective. It's on page 45 of your report pack. And just as an update, Northreps Parish Council Overstrand Parish Council contacted us to reiterate their objection. They're unable to have a representative in the room today. The objection is summarised on page 46 of the report pack as overlooking and privacy concerns to dwellings, security, increased risk of theft and antisocial behaviour, and surface water flooding issues. They're detailed in full as part of the representation online. This is the site location plan of the route which runs from Tulls Hill in Northreps to Northreps Road in Cromer. This slide shows the extent of the footpath again in a bit more detail, and also shows the existing footpaths in Forest Park Estate that the route would connect into. The proposed new footpath sections and upgrades to existing permissive tracks would create a single connected route running from Tulls Hill Overstrand to Northreps Road on the edge of Cromer. Originally, the path was in 3 sections with a western section that had not been completed. This ran from Northreps Road in Overstrand through the woodland and ended near Cart Track in Cromer. This was abandoned during the course of the application due to the timescales required for additional arboricultural and ecological surveys. Whilst it has been removed from this application, it is intended to come forward separately at a later date once additional information can be provided. This slide shows the next slide, please. This slide shows the eastern section in more detail from Northreps Footpath 1, past Overstrand allotments and along the field boundary with Bracken Avenue. There are 2 proposed rest stops on this section of path, the small rest stop at the bottom there in orange and the larger rest stop there in red. This shows the central section in more detail, picking up from the eastern section on the other side of Northreps Road in Overstrand, coming along the old railway embankment and ending in Northreps Road in Cromer. There are 5 proposed rest stops on this section, which can be seen there. Overall, there are 7 proposed rest stops incorporating seating areas, waste bins and multi-sensory interpretation boards. So they're intended to include things like Braille to be installed along the length of the walk. There are 2 sizes of rest stop. The smaller is a 6x4 metre plot for 4 people and the larger is an 8x4 metre plot for 8 people. Waste bins are proposed to be provided at each stop, and these would be managed and maintained by the Forest Park Estate Management. The image to the side there gives you an idea of what the rest stops would look like to the side of the path. The proposed footpath would be approximately 2 metres wide and surfaced to a wheelchair accessible standard. The upgraded surfacing is laid on top of a permeable geotextile membrane with a layer of crushed hardcore and a layer of loose asphalt planings on top, creating a low impact permeable surface. This slide shows the surrounding public footpath connections. The scheme would connect into Northreps Footpath 1 and have links to wider footpath network in the area. Members should also note that whilst this is not a rollback scheme, the proposal would provide a viable inland alternative in advance of any future loss of the existing section of permissive coast path, which runs from Paul's Lane car park in Overstrand along the cliff top through the golf club, and that is actively being eroded. Access is predicted to be severed completely in the relative near future and will require future realignment further inland. Therefore, this proposal would provide public benefit and represents a proactive adaptation measure, which in the first instance extends provision for wider accessibility, but would in future help maintain public access and connectivity despite coastal change and contribute to the long-term resilience of the local pedestrian network. These next few slides provide some photographic site context and views along and from the path. So this view is from Overstrand allotments as the path starts heading west along Bracken Avenue. The image at the bottom there shows members one of the larger rest stop areas. So that's the 8x4 metre section. This is the view west along the path and the boundary with Station Farm, which is located to the north of the path. This is the view from North Reps Road east towards Bracken Avenue. The path does a dog leg around the field corner there. This is a view east along the path towards the allotments. This gives members an idea of the proximity to the part of the path to the dwellings on Bracken Avenue. This is a view up the lane and the access gate. This is the Cromer end of the central section with a view up the quiet lane towards the access gate. This is the central section again, the view east along the path and the first rest stop. The central section and shows existing connections to Forest Park estate paths. This is a view of the central section of path and the access gate on North Reps Road, Overstrand. So, given the location of the eastern section of path and the proximity to dwellings' rear boundaries, a significant number of concerns have been raised by residents in Overstrand, particularly Bracken Avenue, regarding the path and its potential impact on residents' privacy and security. Representations raise concerns that overlooking into residents' garden may occur and that there would be an increased disturbance to residents with risk of trespass, theft and antisocial behaviour arising from users in close proximity to the rear of their boundary properties. The Designing Out Crime Officer was consulted and made a number of recommendations as detailed in the report on page 51 of your report pack. In assessing the proposed footpath, against those recommendations, it is considered that in the sensitive location, the path would be sufficiently wide, largely straight, and would provide clear sightlines for users. The nearby properties would provide an informal level of surveillance of the path, which in itself would deter antisocial behaviour. There would be multiple private access and egress points for adjacent residents too along the path. The use of gates and stiles is also supported to help restrict general vehicle access. A maintenance regime for the extent of the footpath has been set out in the design and access statement and can be secured by condition. No external lighting is proposed, which would also discourage its use at night time. With regards to the amenity concerns, the path is set just over a metre from the property boundaries along Bracken Avenue. As a result of property layout, distances from the proposed footpath varies from 21 metres from the rear elevation of dwellings, such as those at Station Farm, to approximately just over 3 metres. These dwellings currently utilise a variety of boundary treatments to enclose their garden boundaries, many of which are low in height, such as picket fencing, trellis or hedging, to allow views from residents' garden over the open pasture beyond. Officers note that whilst the path would likely not be in continuous use, with football being variable and transient in nature, the intensity cannot be controlled by planning condition. However, the use is unlikely to cause the same level of overlooking as a permanent residential dwelling in this location, and therefore design guide separation distances have not been referenced. Officers conclude that whilst there would be some level of separation and screening, there would be a noticeable loss of privacy at the rear of these properties, resulting in moderate harm from the use of the footpath, contrary to the aims of Local Plan Policy ENV6. There is currently a path used locally which runs around the edge of an agricultural field located between Cromer Road and North Reps Road in Overstrand. Whilst this would avoid the contentious section of path along Bracken Avenue, it would not connect into the wider footpath network with North Reps footpath 1 and is also not suggested by the applicant for your consideration today. So the key issues for consideration then, the principle of development of this nature is considered acceptable in this location. There are no design and heritage concerns. There are limited landscape and visual impacts. The path is permeable, low impact construction and is not considered to cause detriment in terms of flooding. The development as proposed would open up a previously private area of land for public benefit and provide an enhanced piece of green infrastructure for the area, providing a new pedestrian link and encouraging outdoor recreation. The development would also deliver wider strategic benefits associated with long-term resilience at the coastal path network, where coastal erosion represents an ongoing challenge to sections of the existing route, offering an alternative route and maintaining public access. Weighed against these benefits are the amenity impacts. There would be a level of overlooking and loss of privacy to nearby residential properties on Bracken Avenue from a 400-metre section of the footpath. This would cause a degree of harm to residential amenity. However, the extent of the impact would be limited by boundary treatments, distances to dwellings, frequency of use, and the transient nature of pedestrian activity, i.e. there would be no prolonged overlooking. Officers consider that, on balance, the moderate amenity harm identified through the overlooking and loss of privacy is outweighed by the substantial public benefits arising from the scheme. These include enhanced public access to the countryside, improved safety, enhanced recreational opportunities, and greater connectivity, and an alternative route from the coast path. Approval is therefore recommended subject to these conditions. Thank you.
Thank you very much. The Overstrand, you read that out, did yours? Yeah. We have an objecting speaker, Mrs. Petch. You'd like to come up to the microphone at the end there? You got 3. Thank you.
Good morning. My name is Sarah Petch. I speak for the residents of Bracken Avenue and Station Farm. We support the principle of this development, but we object to the 400 metres eastern section of the pathway, just laid a metre over our garden fences. The majority of these residents purchase their properties for the peace and tranquility and to enjoy their retirements. Due to their age, some of these residents are or will be vulnerable in their more senior years. The officer's report is fair and thorough, and we are grateful that it recognises our concerns are real. It finds a noticeable loss of privacy causing moderate harm, contrary to policy ENV 6. So our question for members is purely one of balance, and we respectfully ask you to weigh one thing that the report does not explore. Every benefit of this scheme, the Cromer to Overstrand link, the coastal path resilience and accessibility, would be delivered in full if this one section was relocated. In a previous planning case, the Court of Appeal confirmed that where harm can be designed out by a different alignment on the same land, that the alternative deserves proper consideration. And an alternative exists. The council's own landscape officer advised the applicant that this section needs reconsidering and that a path away from the dwellings would be a preferable route. The Ramblers Association also reported back to the council that the path along the back of the properties seems a poor line to take and that it unnecessarily distresses the residents of Bracken Avenue while lacking distant views that are available higher up on Tolls Hill and Croft Hill. The applicant has declined to amend the plans. Back in 2011, Natural England advised the landowner that they deemed a path in this location as being totally inappropriate due to the privacy concerns for the adjacent properties. At that time, the path did not proceed. So the planning application before you today is unchanged, carrying the very harm that your council's own professionals and consultees said could be avoided. Looking at the document on the screen, this demonstrates how close the path is to some dwellings. The distance to secondary rooms from the path is significantly less than advised in your supplementary planning document, as a comparative table shows for dwellings to dwellings. So our request to you is constructive. Please seek to thoroughly consider an alternative location for this eastern section. Defer this application and invite amended plans for a relocation to higher ground. This would provide the area with a new footpath with spectacular views for walkers. It would protect the residents that are affected, and it will end the 18 months of real distress that's been endured. If the applicant will not amend their application, then we ask you to refuse under policy ENV 6. Thank you very much for your time.
Thank you. We have local member, Councillor Fitzgerald.
Thank you, Mr. Chairman, and good morning, everyone. I wish to make it clear that I'm speaking on behalf of the residents within my ward. It is worthwhile noticing that this application has been funded by Norfolk County Council as access to the countryside. However, the applicant was unaware that engineering works required planning permission, therefore commenced construction of the paths. It is also interesting to note that access to these, and I quote, well-trodden public rights of way, were prevented by locked gates until very recently. Officers have confessed to moderate harm under policy ENV6 to the key qualities of a national landscape, namely a sense of remoteness, tranquility, and wilderness. Personally, I believe that the link between the Suffield Park and Overstrand is important. Several parents use this to walk their children to and from the Belfry School in Overstrand. I will leave it to your imagination as to how they negotiated the locked gates. But that leads me to explain. Alice, could we have, oh, you've got them up. Thank you. I've lost my place now. Another part of this well-trodden route is to the north of the railway embankment. If you look there, the embankment's to the right, and you can walk down beside it, along the hedge at the bottom, and you can see Overstrand Church just there. Okay. Now that takes you directly to the Coast Hopper bus shelter, a linked footpath to Overstrand Beach, which is just past Overstrand Church, or along the pavements to the village centre. Would it not have made sense for the applicant to contact the landowner of this field, or with the permissive path link, and endeavour to regularise this route, which affects nobody? I plead that you refuse this application and with advice to changing the route as, and thank you.
If you have declared a pecuniary interest, then yes, you'll vacate the chamber. Thank you.
Thank you. Councillor Patterson.
Thank you, Chair. Sorry if I've missed it in your report. Have you got a list of conditions? You have. Where have I missed that?
So we've got time, approved plans, materials, external lighting restriction, a management and maintenance plan, and ecological enhancements to be conditioned.
What about something along the lines of sort of no charge ever being levied, i.e. is for public to be able to use without a charge? So a charge isn't put on because it is a permissive path, is it?
Yes.
Yes.
Is a permissive.
So it could be revoked at any time.
Potentially, yes. Yes.
Yeah. Do we not want? Is there anything around that? Do we not want to try and secure it?
Yeah. Yeah.
I mean, that would be beyond the capability of a planning condition, because you're effectively asking the landowner to keep the land open, free of encumbrance, effectively, for use, for rights to be able to pass and repass over the land. I think my understanding that would be something more that a legal obligation would be required to ensure that would happen rather than a planning condition. But I'm happy to take legal advice on that.
I'm happy to. Are we able to put a section 106 or a UU or whatever on it to say that no charge can be levied for use of the path? Yeah.
Yes, I think so. Yeah.
Okay.
Yeah.
Could we consider or vote on having that added as a condition?
learning from what we did from the previous application, we need to ensure the applicant is agreeable to sign up to any kind of obligation of that sort, because if they're not agreeable, then we'd be in a similar situation to the first application.
Councillor Holiday.
Thank you, Chair. How feasible is the alternate route? Because this does seem very intrusive for this particular stretch along Bracken Road. And it's all very well saying it's not widely travelled, but if you're proposing it to be the alternative coast path, it's going to have a very dense footfall. And so I think it will be quite intrusive to those residents' amenity. How feasible is it to go elsewhere? Thank you.
So I'm not aware whether the applicant owns that section of land, and also, we have discussed alternative locations with them. That's not something that they've been willing to negotiate on. So the decision today is based on the footpath in this location.
Councillor Brown.
Yeah, thanks, Chair. I'm equally concerned about this 400-metre stretch adjacent to Bracken Road or Avenue, whatever it's called, Avenue. I think we've acknowledged that it's not about interruption to views, it's about loss of amenity. I suppose what is one person's interrupted view might be another person's loss of amenity, but we won't go there. So, I mean, I would like serious research into an alternative diversion to the footpath for that particular stretch. And I will therefore be urging a refusal on that basis.
Anybody? Councillor Fisher?
Yes, Mr. Chairman, I'm of the same mind. I think I would second Councillor Brown's proposal because I think this needs deferring. That a 400-metre length that needs changing to sort this out seems very little over quite a long length of footpath. I would certainly like to see that sorted out and some sort of deferral for renegotiation.
Thank you. Chair.
Just to clarify, as I understand, there have been discussions about moving the footpath, but those discussions weren't fruitful in terms of the applicant agreeing to an alternative. So absent an alternative and absent ability to negotiate, I think as a committee, you're being asked to consider what's before you. And if you have concerns about it, then you should be considering refusal of the application on policy ENV6 grounds. I think point 2 on policy ENV6 identifies sort of matters that might be relevant for you to consider, but that's a matter for you. Obviously, we've taken a balance, and on balance, we think the benefits outweigh the negatives, but that's a judgment call for you as a committee, and you might tip the balance the other way in terms of the impacts on amenity outweigh the benefits, but that's a judgment call.
Councillor Patterson.
Thank you, Chair. I can see, like you say, it's a balance. I guess if residents on Bracken Avenue feel that their loss of amenity, they've got a PD right to put a 2-metre fence up and have their privacy back. I support the officers and propose the officers' recommendation.
Thank you, Councillor Hankin. Anybody else? No, can we go to the vote then, please, Lauren?
Thank you, Chairman. So we've got a recommendation to accept the officer's recommendation to approve the application. Councillor Beattie?
For.
Councillor Brown?
Against.
Councillor Fisher?
Against.
Councillor Fitch-Tillett is not present. Councillor Hankins?
For.
Councillor Holiday? Councillor MacDonald?
Against.
Councillor Neverway? Councillor Patterson?
For.
And Councillor Vickers. So that is 3 votes for, 5 votes against. The recommendation is lost. An alternate needs to be sought.
Yes, thank you.
There you go. It didn't make a difference either way.
Yeah, go for it, Jeff.
So with the officer recommendation lost, obviously now you have to decide what the next steps are. Obviously, the options open to you are to recommend refusal or to defer to negotiate something else. So obviously it's up to you in terms of the reasons. I'm assuming they're based on amenity concerns for the residents on Bracken Avenue. So I think we've referred to policy ENV6 and protection of amenity, and the second bullet point on that talks about, it says development will not be permitted which causes unacceptable impacts on the amenity of neighbouring occupants or does not provide for adequate levels of amenity for future occupants. So if those were the members' concerns, I would sort of strongly recommend reference to that particular policy and a refusal on that basis, but happy to take alternatives.
Councillor Fisher.
Yes, thank you very much, Jeff. I was going to reference the football last night, and a previous chairman would have done by now, I'm sure. But yes, ENV6 is what it's all about, isn't it? And thank you for making that very clear. And yes, I think we should defer this for negotiation. And the negotiation, you may have a bit more weight now to negotiate with. As long as it's not too Trumpian, I don't mind.
Is that a proposal? Thank you. Councillor Vick.
And I do commend the officer on her very clear report. Yeah.
So in terms of, obviously, we're going to be arming Alice with some tools to go and negotiate an alternative. Just be clear, can I just be clear what it is that we're seeking? How, I don't want to get bogged down into too much detail, but I mean, where does the acceptable line be drawn in terms of how far away from the neighbouring amenity? Because that's or alternatives in terms of screening or landscaping. What is it that you want us to negotiate? Is it both moving and possible mitigation measures? All options on the table?
Oh, well, that's yes. I mean, there's going to be, if we're looking at the 15-metre rule as they obviously were from dwelling to dwelling, it'd be good if it could be at least 15 metres away. If you could mitigate it with a hedge, but that might impair the visual aspect out of their windows. So I think you'd have to look at both things.
You would have the upkeep of the hedge as well,
Yeah,
probably
yeah,
elderly
yeah.
people.
Well, it would depend whose land it was on, of course.
Okay, so we will go to the vote on that.
Yeah, so this is a motion for deferral. Okay. So Councillor Beatty?
For.
Councillor Brown?
Against.
Councillor Fisher?
For.
Councillor Hankins? Councillor Holliday? Councillor MacDonald?
For.
Councillor Neville? Councillor Patterson?
For.
And Councillor Vickers? For. So that is 8 votes for, 1 against for deferment.
Okay. So that's been deferred. Item 9, Blakeney, PF 26. Blakeney, PF 260708, erection of detached garden outbuilding at 8 Worthington Road, Blakeney.
Thank you, Mr. Chairman. Good morning. So this is application PF 260708 for the erection of a detached garden outbuilding. This slide shows the location of the site on Withton Road on the approach into Blakeney. And this is the proposed block plan. You can see the footprint and the siting of the garden room compared to the existing dwelling. This is the site as it is existing at the moment. I'm standing roughly where the garden room would be located when I'm taking the picture, looking west. And this is the same looking north towards the neighbour. And the same looking east towards Withton Road. These photos are taken from a very similar position. I've just stepped back a little bit for a slightly wider view, looking mostly towards the neighbour, but also towards the west as well. These are the elevations of the garden room. There'll be some later slides to show that the roof line that's been designed on the garden room reflects that of the existing property as well. These are very, those are just some perspective views to show it from a slightly different angle as well. These are the sections and, sorry, the section and the floor plans of the garden room. And this slide shows the garden room in its context with the dwelling, so you can see the matching roof line and just demonstrates how it fits in within the context of the site. These photos have been taken from the neighbour's garden, quite close to the boundary, looking towards the neighbour. You can just about see the existing property through the trees. It is accepted at the moment these are in leaf, and there is a seasonality to this, but obviously we had to go out when we did, because when the application came in. And this is the same angle, but just slightly further back, so in the neighbour's garden. This one has been included just to show the relationship to the neighbour. So the rough positioning of the garden room is the yellow box. The blue arrow shows the depth of the trees only to the garden room, so it doesn't extend all the way to the neighbour's property. And it's been measured roughly at about 65 metres. The key issues raised are the design, amenity, impact on the heritage assets, because properties in a conservation area and quite close to some listed buildings as well, and also the impact on the Norfolk Coast National Landscape. We have managed to secure reduced VLT glazing by condition, so we're fairly confident that that's going to mitigate any harm to the national landscape. The distance to the neighbour means that we don't have any concerns that the proposal would be contrary to policy ENV 6. There'd be limited loss of privacy. The glazing faces towards the application site, not the neighbour. Conservation and design officers have raised no issues in terms of conservation impacts of the heritage assets, and the garden room design is considered to fit in with its context. So, and also it's quite subservient to the main dwelling. So officers can contend that the proposal is policy compliant, and the recommendation is therefore for approval. Thank you.
Thank you very much. We got a supporting speaker, Mr. McIntyre. You come up to the end there. You got 3 minutes on that end microphone.
Oh, thank you. Thank you. Thank you. Oh, we can't sit down. Okay, I'll sit. Good morning, Chair and committee members. As introduced, my name is Ross McIntyre, and I am the applicant together with my family. We are a family of 5 with 3 teenage children. This is our permanent residence, and we love living in North Norfolk. Our home is a much-loved, award-winning house. It has received a REBA award and was shortlisted for the Mansur Medal. It sits within a conservation area and an AONB. We take our responsibility to protect and enhance these three sensitive environments very seriously. This responsibility was the central focus of our deliberate design. Our proposed outbuilding will consolidate a growing family life into a single, more concealed structure. It replaces 3 low-quality sheds with 1 highly considered, high-quality singular design. Policies 1, 2, 6, and 7 have all been fully considered by your planning officers. We fully accept their recommended conditions and respectfully ask you to follow their professional advice and approve this application. Thank you for your time.
Thank you very much. We've got a local member, Councillor Holiday. You've got 5 minutes.
Thank you, Chair. First of all, I need to declare an interest, which I omitted to do earlier, and I will be abstaining from the vote. So thank you to the officer for an excellent report. There are concerns this proposal is inconsistent with the character of the locality, namely the adjacent Blakeney Conservation Area, and that it detracts from the Norfolk Coast national landscape by virtue of being visible in a key long view. In addition, it is considered it would reduce the amenity of neighbours, especially in winter. Worries have been expressed about the potential use of this building for residential accommodation. It is thought this proposal is contrary to Blakeney Neighbourhood Plan Policy 6 in that it doesn't preserve or enhance the appearance of the Blakeney Conservation Area or respect the distinctive local character in terms of design and materials. There are also concerns about the protection of the setting of designated heritage assets, namely St Nicholas Church, the Old Rectory and the Village School, all Grade 1 or 2 listed. It is also thought it does not respect or is sensitive to the local character of Blakeney through design and materials. There were worries that the proposed outbuilding will not comply with Blakeney Neighbourhood Plan Policy 12 regarding the preservation of dark night skies. Given the large expanses of glass included in the design, I note the very welcome offer of using reduced visible light transmission glass, but there is potential light spill. Much is made in the officer's report about the role of trees in screening this outbuilding. The proposal is designed to blend into the backdrop of trees in front of which it is sited. Officers note existing landscaping within the curtilage of the application, which will aid as screening the proposed building from the neighbours to the north. Conservation and design make mention of a large belt of tree planting, divorcing the application site from listed buildings in the vicinity. The protection of trees in a conservation area is not watertight. There is absolutely no doubt in my mind that these applicants will do everything possible to conserve their trees which screen the proposed building from the north. This is self-evident through the exemplary tree protection measures proposed during construction as part of this application. However, as discussed in the first case today, situations can sometimes change unpredictably. In conclusion, there are concerns this application does not apply with local plan policy concerning the conservation and enhancement of the key qualities of the Norfolk Coast national landscape, that it doesn't comply with the policy that requires a development be sympathetic to the key characteristics and valued features of distinctive character areas, and the one not causing that development shouldn't cause unacceptable impact on the amenity of neighbours. And there's also concern that this proposal doesn't conserve and enhance the historic environment. Thank you very much.
Thank you. Anybody like to start the debate? Councillor.
Just a question to start. I wondered what the dimensions of the proposed building actually were, the height and floor plan.
If you look on page 60 of your agenda, sort of on the section 2, scale and impact of building, I think about the third paragraph down, it does sort of set out that the detached building is approximately 11 metres long, 7 metres wide, with a maximum height of 3.5 metres. It's a more difficult or challenging building to measure the height because there's varying different sort of eaves heights on it, but hopefully that gives you a broad overview.
Yes, thank you very much. Found it.
Councillor Brown, thank you.
Thank you, Mr. Chairman. Well, this particular case demonstrates why we're probably having a national scheme of delegation coming in after the end of September. This will not, or this type of application will not be coming before this this committee. I'm just wondering whether the architects, perhaps the applicant can answer, has used, sort of heritage conservation, that they're accredited for, heritage or conservation. I'm guessing they are, because conservation and design have approved this. It's, they've backed it, as we can see in the report, and they've said that there's no no impact on the heritage, even though it's close to St. Nicholas Church, which is a significant heritage asset. I'm interested as well that it replaces 3 low quality sheds. So you could actually argue that it's tidying up an otherwise challenging or inferior impact on the local environment. So I think all things considered, we know from Blakeney Neighbourhood Plan Policy 12, which does come before us with considerable regularity, that we can manage that through condition. And because obviously light spillage is extremely important for our area. I would just ask, I'm going to recommend approval, by the way, propose approval, Chair, that in so doing that we make sure there is a condition attached by the committee, should we move to approval, that that this structure is not sold separately. It's, in other words, tied to the main dwelling of the family home. And also that it will not be considered for conversion either into residential accommodation or accommodation for tourism. Should we approve it, Chair? That's me done.
Does she want to say anything? Okay, yeah, there you go. Yeah.
Yeah, just to say there is a condition that the garden room is used for incidental purposes to the dwelling already as a condition. So I don't know if you wanted that strengthened or if that was sufficient for what you were thinking.
Yeah, well, I mean, also, any rights to change it to, the use for tourism. I mean, obviously, if it's tied to the property, it will have a residential accommodation use in conjunction with the main dwelling. So I probably shouldn't have said that, but I wouldn't want it to become a holiday let. Basically, that's what I'm trying to get to the bottom of.
Yeah, I mean, the condition that Nicholas suggested is that it's incidental to the use of the main house as a dwelling. So if it were to become a separate holiday unit, that would be a material change, a change of use, as in a separate planning units being created.
So it would have to come back.
It would have to come back for planning
Yeah.
permission for that anyway. So,
That's fine.
yeah,
that's fine.
Thank you.
Thank you.
Councillor Vickers.
Thank you, Chairman. I noticed that the conservation team have approved this, and I don't think conservation rules should be used to spoil people's enjoyment of their property. This is, well shielded by trees, so I can't really see, I mean, we saw from the picture that it was several trees deep, so I can't see how even in winter it unnecessarily impacts the neighbours. The applicant said or suggested that it was mirroring the house. Do we have a picture of the house? Because I think that building materials, if the house is an award-winning house and this mirrors the house, I don't think we should have any objection on the grounds of its appearance. Do we have a picture of the house or even of the sheds that it's going to replace? If we haven't, never mind.
I don't think I've got any specific pictures of the house as a whole, and we potentially were able to get on Street View. I'm not sure if we can. The materials are slightly different. They're charred timber.
Yeah.
but it's more the design and the shaping of the outbuilding that's mirroring the main dwelling rather than
Okay,
materials. So
that's fine. You've seen the site, haven't you? So
yeah, well, I don't know if you'd be able to get that
I
perspective.
can, no,
view
but I
back
can
up.
rely on your description. That's
Okay.
fine. So I'm very happy to second Councillor Brown's.
Thank you, Councillor. Councillor Patterson.
I've been beat to it. Thank you.
Councillor Hankin.
Thank you, Chair. There's a condition, VLT glazing. What is VLT glazing? Presumably it's something to do with vertical glazing, maybe. And why is that important as a condition?
Yeah, it stands for visible light transmission, and it reduces the amount of light that comes through the glass. But I think maybe Councillor Holiday, did I interrupt you? I'm sorry.
Glazing expert, you're the glazing expert. But it is designed to reduce the amount of light spill, isn't it? Yes.
Condition of light then. Yeah, okay, thank you.
Thank you. So, oh, very good. Can we go to vote, please, Lauren?
Thank you, Chairman. So this is a recommendation for the officer's recommendation for approval. Councillor Beattie?
Oh.
Councillor Brown?
4.
Councillor Fisher?
4.
Councillor Fitch-Tillett? 4. Councillor Hankins? Councillor MacDonald?
4.
Councillor Neverway? Councillor Patterson?
4.
And Councillor Vickers? 4. Of the 9 members voting, that was unanimous 4.
That's authorised. Right, so number 10, we've got a TPO in North Walsham. Sorry, Imogen, I didn't give you time to get to your seat there, sorry.
Thank you, Chair. Thanks, committee. We're considering a tree preservation order for one oak tree at North Walsham in the southwest of the town, land off Ketts Road. Here we have a site plan, and you can see the tree location there surrounded by housing, but sitting in its own sort of small open space. And here's an aerial of the tree that shows the sort of context of the housing around it. And I like to look back. There's the housing on the left on the RAF map shows that development coming down Recreation Road, and the sort of ongoing into the 80s as the Burton Avenue housing sort of is coming forward. And you can see quite a distinct hedgerow reaching out into the previous countryside land there. And this oak tree is part of that old landscape feature. In 2009, Orbit Housing put forward a development there to erect 16 dwellings, and the oak tree was specifically retained as part of that open space provision for those housing. And here's a sort of site visualization produced at the time. And here we have the tree today in winter and in leaf, and you can see it sort of sits in that open space. And from Ketts Road there, it's visible from a number of positions in North Walsham. And this is a close-up, excuse me, of the tree. And you can see there are some low branches, and it does extend into the neighbouring properties. We have had just one objection, and both housing associations supporting the order. We think the order gives us more control over pruning work that needs to happen periodically. The housing associations have confirmed that the oak is being maintained in line with their tree management policies, and this gives us the tools to make sure any work that comes forward is done to a good standard. So we're recommending that the order is confirmed. Thank you.
Thank you. Do you want to speak on? Okay. So, Councillor Fitch-Tillett.
Yeah, thank you, Mr. Chairman. Oak trees are important. Oak trees are special. yes, all right, some of them grow a little bit beyond where they should be, but they do, if they have to be, did you prune an oak tree, or I'm not quite sure the right terminology there. It has to be done properly by a recognised tree surgeon. So I'm more than happy to propose the recommendation.
Thank you. Councillor Fisher was first.
I'm going to beat Councillor Patterson to it again and second the motion.
Councillor Brown.
Purely on a different tack, I heard yesterday that the grand oak in Sherwood Forest, for the first time since God was a lad, is not leafing this year. So I think in the memory of the grand oak in Sherwood Forest, we should move to approve this application, Mr. Chairman.
Do you want to speak, Councillor Pat? No. So we just go to the vote, or does anybody else? Yeah. I'll go to.
Thank you, Chairman. So this is a motion to approve the order. Councillor Beattie.
4.
Councillor Brown.
4.
Councillor Fisher.
4.
Councillor Fitch-Tillett. 4. Councillor Hankins. Councillor Holiday. Councillor MacDonald.
4.
Councillor Neverway. Councillor Patterson.
4.
And Councillor Vickers.
4.
That is unanimous, 10 votes for. Thank you.
Motion passed. Thank you. So item 11, development management performance update. Jeff.
Okay, so page 67 of your agenda, just a performance for the period of March this year. So, yeah, we're continuing to maintain the performance across the department. Our 24-month figures, which is the right-hand column, 97% for majors and 94% for non-majors, all within time. So that's well above the national average. We're just working on making sure we keep the non-majors figure up. So it's down to 88% for that period in time. We're just trying to do what we can to avoid any unnecessary ones going out of time. But other than that, the performance is very good. And again, in terms of the quantity assessment government doing in terms of the number of appeals that get allowed, can't really beat 0 for majors, and a non-majors figure is, say, less than 1% get overturned. So yeah, very enviable figures, and we'll continue to keep up the good work. We do have the list of section 106 obligations. I don't know if Fiona wanted to provide any comments on those.
Yep, just really quickly, the Honeybell's already gone through, and I just want to thank Mr. McNichol of the study estate for being really efficient and effective and getting that through really quickly. So if we are on YouTube, thank you very much, Mr. McNichol. And yeah, the one, the Hempton Poultry Farm site, the shipping containers, section 106, we do understand is now being signed. So that should come off the list next month.
Councillor Brown.
Yeah, just going back to the development management performance update. What we don't have, and what would be interesting to have, is the comparable figures with our neighbouring local authorities, who are obviously, you know, a leafy oak green with envy when they look at these figures. I'm just saying.
Maybe not, now that we don't have platinum.
Yeah, I wasn't going to mention that because, you know, as you know, Chair, I don't like to mention that too often.
I mean, we are working on a Power BI module for performance, which I've asked the team to put together, which will pick up quite a number of different stats. Quite when that's going to be ready, I know the team's under a fair bit of work pressure to get some of the BI modules for the officers, so we can actually get decisions out on time, because that's a critical element here, that we don't keep customers waiting and we make timely planning decisions, because that's the thing that I'm sure you as members get. If there are criticisms, it's usually about the timeliness of decision making. That's the bit that we have been working hard to improve over recent years. But certainly we can, and we are working on stats to bring to this committee that we can sort of highlight our performance. Whether we benchmark that against neighbouring authorities, we'll need to check, because obviously not all authorities are alike in terms of their size and their comparability. So it might be hard to do that against an authority that's effectively 2 authorities combined. So, but we can look into it, certainly.
Thank you. I think that concludes. I thought you did that. Sorry, appeals. But thank you. 12.
Right, so appeals on starting on page 71 of your agenda. We have had quite a number of new appeals coming in. This is only shows a small selection. I think we've had about 9 in the last few weeks. So yeah, so the workload for the officers on appeals is going up. The inspectorate have actually churned out a couple of decisions. So we've had 3 decisions issued on page bottom 73 and on 74. 2 of those were dismissed and 1 was allowed. The one that was allowed was a boundary fence around a property on the Bush estate. We had concerns about the impact of the fence on amenity. The inspector basically took a differing view and felt it wasn't completely out of character. So it's not a critical decision. It's not going to have a huge effect on how we determine other applications. It's just disappointing that obviously the inspector took a view that was different to our own. But they're entitled to take that planning judgment as we do as a committee and officers as well. But yeah, performance on appeals continues to be strong. And then on the last sort of page 75 and 76, you've got the ongoing enforcement appeals. I think you'll notice the absence of many decisions from the inspectorate. It seems they do struggle with determining enforcement appeals, which I don't think it's just for North Norfolk. I think it's across the country they're having some delays in determining those types of applications. Thank you, Chair.
Thank you. Sorry about that. Well, I think that concludes the meeting. Sorry? I'll close the meeting.